It's not in all the cases where the Director of Youth Protection is involved that the parents and children will have to come to the tribunal or to court. If everyone agrees on the reasons why the director is involved and they're motivated to act and they're able, then everyone can write kind of a contract. It's called a voluntary measure, and we don't have to go to court, but the director will be involved with the family then. There's many ways that we can be invited to come to court. First, if there's an emergency hearing, the social worker can call the parent to inform them to be in court the next morning. There's also a notice to appear that can be sent to the parents, and that's in a written form. And in the notice to appear, you'll find the date, the location of the court. It's kind of an invitation to come to court. There is also a subpoena that can be sent to the parents, and that's not an invitation, that's an order from the court to be present. It's always normal to be stressed when you're asked to come in front of the court. I'm a lawyer, it's been 20 years, and I'm still stressed. It's normal. Remember when you were asked to do a presentation in front of a class, how stressed you were, and now you're in front of a court. It's normal. You just need to stay calm and explain your situation as simply as possible. When in court, a parent can be assisted by a lawyer. They don't have to, though. You can choose not to be represented by a lawyer, and you can choose to present yourself and to present your case and your facts in front of the judge. If you want to be represented by a lawyer, it can be arranged. There's lawyers specialized in youth protection, and they can represent you. They represent only you. They can counsel you and help you in court. The child and the Director of Youth Protection will be represented by other lawyers. If you're eligible to legal aid, and this is decided depending on your income, the state could pay in part or in full the salary of your lawyer. If you're not eligible to legal aid, that means that you'll have to pay for the service that your lawyer renders you. If you want to prepare yourself to come to court, it's important to review what was said to the Director of Youth Protection worker who interviewed you. What were the facts, to try to organize them in order to present them the best way in front of the court. You just need to remind yourself of important facts. You could also bring documents that you feel would be important for the judge to read, and if need be, also ask for witnesses who had seen or heard things that you presented to the Director of Youth Protection. There's two types of witnesses that can be brought to court. The first one is the ordinary witness. This is the person who has seen or has heard what's happening and is reporting to the tribunal. There's also the expert witness. Those are, they could be psychologists, they could be doctors, or another expert. And they don't report on what they've seen, they report on opinions. Everyone is curious about how you dress to come to court. Court is not the beach. So you don't wear flip-flops, you don't wear a tank top. You dress in a professional manner, or you dress in a sober manner. The judge, when the judge hears your testimony, the judge will hear what you say, but also look at how you behave and look at how you're dressed. So the judge will look at your nonverbal attitude also. Everyone could ask you a question, you're a lawyer, the lawyer from the other party, but every time that you answer, you always answer in direction of the court, of the judge, because it's the judge that you have to convince. Every party will have the time to make their own proof, so to present their own witnesses and to present their own documents. Often it's the Director of Youth Protection who starts, and then each parent has the opportunity to present some proof and to testify. When this is all done, the lawyers sometimes will plea, will argue in front of the judge. They could present some jurisprudence. This is the decision from other judges regarding the same topic to try to convince the judge of their point of view. Once this is done, the judge will make the decision. It could be done on the bench, so the judge heard everyone and is ready to make his or her decision and will render the decision in front of the parties. The judge could also take the case under advisement. That means that he or she will take some time to reread reports, relook at documents, or re-listen to some of the testimonies, because everything we say in court is recorded. If any party is not in agreement with the decision of the judge, they have the opportunity to make an appeal of the decision. It's done in front of a different court. In youth protection, the first time we go to court is in front of the youth court, Court of Quebec Youth Division. But when you appeal, you go in front of the Superior Court.